In this video, we're going to be looking at the ET1 Employment Tribunal Claim Form and how to start your employment tribunal. My name's Alex Monaco, owner of Monaco Solicitors. You can also check out other videos in this playlist about employment tribunals, subscribe to the YouTube channel, and check out the website too for more information on all of this stuff. In this video, we're going to cover three main parts of the ET1 form. So what to include in the ET1, what not to include in the ET1, and whether you should get a lawyer to help you with your ET1 form. So what to include in your ET1 Employment Tribunal claim form? Well, this is the foundation of your Employment Tribunal claim. If you forget to put anything in, or you didn't put something in correctly, then sadly, you're probably never going to be able to have that justice for that particular thing, because you've got your 3-month time limit, which is in all employment law claims pretty much, well, technically it's 3 months minus 1 day. So by the time you've realized, by the time your case gets to court, if you haven't put something in your ET1 initial claim form, you'll be out of time and it'll be too late to go ahead and put that back in. So you need to include everything in there that you want to rely on in court. What do I mean by everything? Well, certainly you're going to need to put enough information for a judge to understand what you're claiming about. For example, if you are unrepresented, so if you are what's called a litigant in person, you can perhaps get a bit more sympathy from a judge. But let's say you've been discriminated against on the grounds of your race, and you say, okay, I was discriminated against because I am of Asian origin, for example. Well, you won't necessarily need to put the section number of the Equality Act in your ET1 for a judge to understand that. So long as you say, well, I was discriminated on the grounds of my origin, my Asian origin. So in that sense, you won't necessarily say, well, that was section 19 or section 20 of the Equality Act. So you don't have to put every single legality in there, but you do need to say enough so that the judge can understand your case. You will also need to put some of the facts of your case in, and the best way to do that is to do that in bullet points. So just try to do the research before you go ahead and write out everything. What not to put in an employment tribunal ET1 claim form, very important too. So what it shouldn't be is a long form account of everything that happened. It shouldn't be pages and pages of facts. Judges have made it very clear they prefer bullet points when it comes to the facts, because you will get a chance to write your story in long form in your witness statement. That can be pages and pages of facts, and that will come later on. So in the ET1 claim form, try and keep it short, a few bullet points just to support each subheading. So your kind of legal subheading, well, race discrimination, unfair dismissal, whistleblowing, and then under each heading, a few bullet points to say, the key events that happened. But you don't need to go into who said what, when, and when necessarily, unless it's very much key to that subheading. So what not to put in is chapter and verse on what happened to you throughout the last however long in your employment. Now, whether you need lawyers to do an ET1 Employment Tribunal claim form for you, or whether you should do it yourself, we would say that you can do it yourself, and the system is designed supposedly to be accessible for people to do it themselves. But if you have got any budget for lawyers, now's the time to spend that budget and allocate that on the ET1 claim form. That's the part that you want to get your lawyer to do. If you only could get them to do one thing, it would be that, because it is the foundation of your whole case. And if you put something in wrong, or if you forget to put something in at all, or you don't include something sufficiently correctly, you can run out of time. You'll never be able to rely on that. So your lawyer will get it into good shape. Not only that, but there's that psychology as well, where if you think about your employer receives this claim form in the post, or by email, if it's been written in a very legally precise way, it looks like it's been written by a lawyer, they're going to be a lot more concerned than if they receive it from you personally, because, well, they're going to know that they're much more likely to end up in tribunal because you've already got lawyers. So they'll be able to tell that from the way it's written. There's a lot of value in that, because you will then be offered a higher settlement from them. You know, they will offer you more money, basically, to out of court to withdraw the claim. Whereas if they think that, well, this person hasn't got budget for lawyers or can't convince a lawyer to do this case on a no-win, no-fee or something, they're more likely to say, oh, well, we can string this out, kick the can down the road, and we'll go along the steps of the tribunal process, and sooner or later this person will just drop out. So that psychological factor is worth thinking about, and it can be an upfront investment to spend a bit on lawyers in order to get a lot more back in the long run. Hope you've enjoyed this video. Don't forget to subscribe to the YouTube channel and check out the website. Thanks very much.